let's take a look at this order in the Sarah Boone case that was made on June 28th. The cause came before the court on June 28th, 2024, on defense counsel Patricia A. Cashman's motion to withdraw, filed June 11th, 2024. The court having reviewed the motion, having reviewed the court file, having reviewed the audio transcripts from various hearings, having considered the positions offered by counsel, Patricia A. Cashman, Esquire, having considered the testimony offered by defendant, Sarah Boone, and having considered the positions offered by counsel for state, hereby finds. So, I want to point out the court didn't just listen to the lawyer, considered the testimony offered by the defendant, Sarah Boone. She was included, she was heard, and the judge considered what Sarah had to say. So, when you hear later a complaint about nobody listens to me, I can't be heard, all of that, it's right here in black and white. These are the things that the judge considered. On March 23rd, 2020, she was charged with second-degree murder. And they go through the history here. And I'm likely going to make comments. I haven't read this until now. If you've already heard all of this history and you don't want to hear it again, you can fast forward. On February 26, 2020, the Office of the Public Defender in Florida, so attorney number 1, was appointed to represent defendant. On March 9th, 2020, the public defender moved to withdraw due to the defendant retaining private counsel, to wit, Mauricio Padilla, I hope I'm pronouncing that right, and the Padilla Law Group. So this is attorney 2. And fair enough, Sarah has the right to hire private counsel if that's what she chooses. She technically did fire the first attorney. Not saying she doesn't have that right to do that, but she did. So when she yells about how she's never fired an attorney, technically that's incorrect. But I'm not going to be all that hard about this right now. Let's keep going. On March 11th, 2020, the order allowing the withdrawal of the public offender was entered, and that withdrew the public defender from further representation of the defendant. On April 18th, 2022, 2 years later, Padilla moved to withdraw due to irreconcilable differences arising between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. This motion was served upon the defendant, and the defendant confirmed receipt. See letter dated April 20th, 2022, and filed on April 26, 2022. The other piece of this is that they were getting pretty close to trial. And as we're looking at this in hindsight, it's easier to see certain things. And I'm now thinking, was she getting close to trial and was really anxious about that? Did she want answers and assurances that were impossible to give? And irreconcilable differences generally don't pop up just overnight. So it sounds like this had been going on for a while, or at least brewing for a while. And sometimes a lawyer will keep trying, thinking they could push through or work it out, or once the trial's over, it's all going to be over anyway. But if the client gets worse, well, then you got to do something. And the other point here, and this is going to be true for every attorney, is that it is difficult to convey all the details to the court and still maintain the duties you have as a lawyer to the client. Also want to point out about this one is that the defendant did receive a copy of this and she responded. On April 29th, 2022, a hearing was held on Padilla's motion to withdraw. At the time of this hearing, Padilla had been representing defendant for 2 years. Defendant was present for the hearing and was sworn. The court advised Padilla that the court had received a letter from the defendant, the one dated April 20th, which seemingly objected to Padilla's withdrawal. The court advised Padilla that the options were to not proceed on Padilla's motion to withdraw or provide the court more about the irreconcilable differences. Oh, again, in hindsight, we know that Sarah wants to be able to be abusive toward people and have them just take it. And she doesn't want the lawyer to leave. She wants the lawyer to obey and come under her control. And if the lawyer leaves, well, she doesn't have her little punching bag anymore and has to deal with a whole new thing. Whether it's a lawyer or somebody else with her, I suspect the message is kind of, let me hurt you, but don't leave me. And I want to point out here that because Sarah appeared to be objecting to this lawyer withdrawing, the court said to the lawyer, you need to come up with something better or you have to keep representing her, basically. So the court actually took Sarah's side, or at least leaned more toward Sarah's side on this. Of course, they didn't know then what everybody knows now. They're giving her every opportunity. So they asked this lawyer, well, you better give us something better. Explain it a little bit more. So Padilla requested the opportunity to amend the motion to address this. The court reserved ruling and gave him until May 3rd. So he only had a couple of days to prepare this. The state advised of Padilla's diligence in preparation, and the court commended Padilla's work. The defendant testified to a lack of trust between herself and Padilla. I discussed this issue of that lack of trust and what she's claiming in my response to that April 20th, 2022 letter. I talked about that there. So if you want more commentary on that, go look at that video. So Sarah has the opportunity here to complain. She seems to want him not to withdraw, yet at the same time is saying she doesn't trust him. On May 4th, 2022, Padilla filed an amended motion to withdraw, which supplemented the original grounds. 1. Undersigned's relationship with defendant has become adversarial. The aforementioned adversarial relationship has interfered with undersigned counsel's ability to effectively represent his client, especially preparing for trial. Adversarial. That's a stronger word. 2. Undersigned appreciates the court providing him the opportunity to amend his previously filed motion to withdraw. However, after further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client, and as such will stand mute on the specifics. Let's use some of Sarah's words here. Professional, appropriate versus inappropriate, and honor. This lawyer spent time doing research, looking at this, thinking about this, and was concerned that in stating what he wanted to state, in defending himself, in making his argument, he might disclose something that would hurt her. And so instead of doing something that might hurt the defendant, he stood mute and was willing to stand there and possibly not get what he needed from the court and possibly look bad. And she's spewing the things she spews and she's slinging mud, and he can't defend himself because in defending himself, he might hurt her. And that's what he chose to do. Is that professional? Yeah, I think so. Is it inappropriate? No. And is there honor in that and integrity in that? Yeah. And I think this is important to note. On May 6, 2022, Padilla filed a second amended motion to withdraw, which further supplemented the original grounds. Undersigned relationship with the defendant has deteriorated to a point where undersigned counsel can no longer give effective aid in the fair representation of Ms. Boone's defense. This motion is in compliance with, and he names the rules regarding the Florida bar are present, or whether the attorney-client relation has deteriorated to a point where counsel can no longer give effective aid in the fair presentation of a defense. So May 4th, he's filed an amended motion. He comes back on May 6th to file a second amended motion. And what he's saying is, this is really bad, Judge. It's really bad. On May 10th, 2022, a hearing was held on Padilla's second amended motion to withdraw. Defendant was present for the hearing and was sworn. Padilla advised the court that he had no other choice to file the motion due to ethical concerns. Defendant confirmed that she wanted to terminate Padilla as her attorney. The state expressed concern of a strategy to allow defense attorney after attorney to represent defendant. You see, the state was onto this pretty quickly, and they brought it up. And Boone can say, no, I didn't terminate Padilla. He wanted to leave and I let him go. So she's gonna argue, well, not my fault, right? And she talks about these attorneys all bowing out ungracefully. I don't know, man. I think that lawyer standing there saying, look, if I say anything, I'm gonna hurt this defendant. So I'm not going to do that, and I'm going to stand here and have to stand mute. I don't think that was ungraceful. I don't think he crept away. The court advised defendant of the state's concern regarding a strategy of the defendant being unhappy with every attorney and advised defendant about the dangers of self-representation. This is 2 years ago, more than 2 years ago now. She was warned. And over 2 years ago, the state had her pegged and brought up this concern. She was there. It was spoken in front of her. She knew that they were onto her, but she's going to do what she wants anyway. And I think she fully expects to get away with everything. The court appointed the public defender, attorney number 3. On June 6, 2022, the public defender moved to withdraw due to a conflict. On June 7, 2022, that certain order allowing public defender withdrawal was entered, which withdrew the public defender from further representation of the defendant and appointed the Office of Criminal Conflict and Civil Regional Counsel and attorney number 4. On June 10th, 2022, RCC moved to withdraw due to a conflict. On June 22nd, 2022, that certain order allowing the Officer of Criminal Conflict and Civil Regional Counsel withdraw was entered, which withdrew RCC from further representation of the defendant and appointed Mark Consuelo. I hope I pronounced that right. So that is attorney number 5. That's June 22nd. Only a couple of weeks later, July 8th, Consuelo moved to withdraw due to a conflict. On July 11th, that withdrawal order was entered, which drew Consuelo from further representation of the defendant and appointed Frank Bankowitz. He is attorney number 6. On July 12th, 2022, Bankowitz in open court requested a continuance due to his recent appointment, and same was granted. Makes sense, right? Thereafter, the court set a pretrial conference for October 25th, 2022 at 9 a.m. and trial during the trial period beginning November 7th, 2022. On October 25th, 2022, the court held the pretrial conference and addressed the court's understanding that a continuance was being sought, and the court's judicial assistant was to reach out to the parties to confirm if a continuance was being sought. On October 27th, 2022, Bankowitz filed defendant's motion to continue, so he's working on the file. On October 28th, 2022, the court entered that amended order on defendant's stipulated motion to continue, which set a pretrial conference for January 17th, 2023 at 9 a.m. and trial during the trial period beginning January 30th, 2023. On November 22nd, 2022, the court set a status hearing on Tuesday, December 20th at 10:45 a.m. On December 19th, that's the day before the status hearing, Bankowitz moved to withdraw due to irreconcilable differences which have arisen between the undersigned, his client, and his family. The undersigned will be unable to effectively and properly continue representing the defendant herein. So on December 20th, the status hearing was held. Bankowitz didn't appear due to a car accident, and the court reset that for December 22nd at 11 a.m. On December 22nd, we're still in 2022, the reset status hearing was held. Bankowitz appeared virtually. Remember, the guy's in a car accident, right? Due to technological issues, Bankowitz was unable to hear the court. So the court reset the status hearing for December 27th. That hearing was held on Bankowitz's motion to withdraw. The defendant was present for the hearing and was sworn. The court advised the defendant that the court had received letters from the defendant, a letter dated October 3rd, 2022, November 3rd, 2022, and December 5th, 2022. So she's writing like once a month. And I believe I've covered all of those letters in previous videos. The court conducted a Nelson hearing and the defendant was not seeking to remove Bankowitz. Bankowitz advised the court of the thousands of pages in discovery that he had received and organized, and his contact and potential use of and collaboration with expert witnesses, including experts that Padilla, who is attorney 2, utilized. Bankowitz advised the court of defendants' attempts to call Bankowitz at a rate of 5 to 10 times a day. Bankowitz further advised of his efforts to balance the demands of other clients with the defendant's expectations for communications. And remember, Sarah was saying she's calling and nobody answers. Well, you know what? If somebody's calling me 5 to 10 times a day, I'm not answering either. This is not the same as a lawyer refusing to communicate with a client. In response, defendant reposted that Bankowitz's representations were untruths, raised Bankowitz's prior public reprimands for lack of communication, alleged Bankowitz's action in this case rose to a similar level. I can't help but chuckle a little bit here because this is bolded. I mean, the court isn't going to put things in big capital letters that the same way Boone does, and then sought to remove Bankowitz. So when Boone says in the letter we just read, she's never terminated an attorney, we know that's not true. Also, refer back to those letters in respect to these phone calls and the way she makes the allegations and how she presents it out of context. And of course, it's everybody else's fault, and he's horrible and mean. And she's accusing him of lying, basically, on the record. So serious. And then on the record and publicly, and I believe in a letter, raised something negative about him that happened before, and she's going to use it. And I think it's the same way now with the detectives. She is going to try and find anything bad about them and try and use that, exploit it, whether it's relevant or not. She is going to jump onto a sliver of something, a tiny grain, and blow that up and twist it and try and use it to her benefit. And even if it's not to her benefit, at least denigrate the other person. And she did it to Bankowitz, right? This is who she is. She did it to Mr. Torres. When she was in the police interviews, she said things about her neighbors that were very derogatory, and even at one point suggested that somebody was in the country illegally. This is who she is. Bankowitz further advised of his efforts to balance the demands of other clients with the defendant's expectations for communications. This is Sarah. She doesn't care about anybody else. Nobody exists except for her, and other people don't exist except to the extent that she can use them. Oh, I just realized I reread that. Okay, where was I? The court pointed out defendants' inconsistent statements within minutes of them being made and addressed concerns over the defendant's motivations, especially when there is something the defendant disagreed with. Sarah thinks that she can just say what she wants And because she's smarter than everybody, nobody's going to catch on to inconsistencies. Nobody is going to see a pattern. Nobody's going to catch on to the games that she's playing, that what she's doing isn't obvious. So they called her on it. The court specifically advised the defendant that she is not entitled to an endless line of court-appointed lawyers until you find the one that you personally prefer. You don't have to like them. They have to be a competent lawyer, and that's it. And this was explained to her. And I note the footnotes here. In crafting this order and setting out this procedural history here, the court is not saying, oh, well, yeah, you said this. They have receipts. And throughout this, they're making the footnotes so that anybody who wants to later on down the line can go and find exactly what it is that the court is making reference to. So here we have the November 3rd letter and the December 5th letter, and it's specific what the issue was, what page it was on, so that the record here is clear. This has been explained to Sarah. She's been called on her behavior. Again, how it works has been explained to Sarah. But remember, if she doesn't like an answer, then it's a non-answer, right? It has been explained. She was there. The court also explained the circumstances where defendant could represent herself. Ultimately, the defendant did not request to remove Bankowitz. The court denied Bankowitz's motion to withdraw and directed Bankowitz to have a conference with the defendant prior to the pretrial conference previously set for January 17th, 2023. Sarah complains, unfair, nobody listens to me, nobody hears me. Well, she is being listened to, she is being heard, and once again, the court leaned it toward giving her what she wanted, not what Bankowitz wanted. So this is not something where the court is just being mean to her. The case was continued several times due to Bankowitz's attempts to retain an expert through JAC and JAC's response to same. Bankowitz is obviously working on it. He's trying to get this expert. Of course, these things take time, right? You're back and forth with the expert. He's trying to negotiate around fees, and then he was trying to negotiate with JAC about those fees because they weren't going to cover that amount. It was over the limit. And so he was making argument, all that. So Bankowitz was working on it. He was trying to get this expert. So that's why it had to be delayed. During this time period, the court had received several letters from the defendant, a letter dated January 10th, 2023, March 22nd, 2023, and April 6th, 2023. Oh, and May 15th, 2023, and June 29th, 2023, and August 2nd, 2023. On August 22nd, 2023, Bankowitz again moved to withdraw due to irreconcilable differences arising between undersigned and the defendant that have made it impossible for the undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. And she's on this letter writing campaign just trashing this guy. What's happened up until now? She treats somebody like crap. She is uncooperative, and goodness knows what else that went on behind closed doors that we can't know about and the lawyers can't tell anybody about. The lawyer tries to leave and she says, no, don't take away my punching bag, please. And the court has taken her side. And so she gets to just behave however she wants, all the while screaming how unfair it is. So Bankowitz files this on October 22nd. And part of Bankowitz's motion included the defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can dedicate his or her time solely to Ms. Boone's case. Yup. And I suggest to you that she won't be satisfied with any attorney, even if they could dedicate his or her time solely to her case. If the attorney moved into her jail cell and was chained to her 24/7, she still wouldn't be satisfied. That's who she is. The best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. Yes, no attorney can satisfy her. On September 8, 2023, a hearing was held on Bankowitz's motion. The defendant was present for the hearing and sworn. A lot of you remember this. Bankowitz addressed defendant's derogatory statements, i.e. dud, buffoon, and berating behavior. And we heard it. We saw it in the letters. Yet in her letter, she also complains that people ought to be more respectful to her and more welcoming. The court advised defendant that the court had received letters from the defendant, a letter dated August 26 and August 30th. After the court's colloquy of defendant and her acquiescence to Bankowitz's withdrawal, the court granted Bankowitz's motion to withdraw and appointed Winston Hobson, attorney 7. Thereafter, the court set a status conference for October 30th, 2023 at 10 a.m. and a pretrial conference for November 28th. After setting these dates, the court pointed out the deterioration of the working relationship between defendant and Bankowitz. So this is the court, the judge, saying to Sarah, hey, we saw all this. We noticed this. The court further cautioned that if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. Meaning, so far, you've been given a pass, but we're seeing a pattern here. And I reiterate, the state called it right away, right at the beginning. The court further advised that there are certain decisions the attorney gets to make and certain decisions a defendant gets to make. That is, go to trial and or testify. The court cautioned as to the defendant's unrealistic expectations regarding court-appointed counsel and reminded defendant of her right to retain private counsel. So again, she has been heard. She's getting a new lawyer again. And the court is also saying, look, maybe you're not quite understanding what you can and can't expect. And here are your rights. And we're seeing a pattern. So don't expect to be getting away with everything forever here. So that was September 8th, 2023. And I have lost count of how many times she has been warned. On October 30th, 2023, the status conference was held. Hobson advised as to his conversations with the defendant and setting a status in January 2024. Thereafter, the court set a pretrial conference status as to readiness for trial for January 16th, 2024, and a trial during the trial period beginning January 29th. On January 12, 2024, Hobson filed that certain motion to continue, waiver of presence, and requested a 3-docket continuance. On January 16th, the court addressed Hobson's motion to continue, granted same, set a pretrial conference for May 3rd, and trial during the trial period beginning May 13th. So again and again and again, the court is making accommodation. So now there's a new lawyer. There's no way he is going to be able to prepare for a trial, especially if he's thinking he needs to get an expert. There's no way he's going to be able to prepare in time. So everything is just set back. On February 1st, Hobson moved to withdraw. He hadn't been her lawyer very long at all. And as of January 16th, he wanted a motion to continue. He was preparing, but then 2 weeks later, he's moving to withdraw due to irreconcilable difference, including, but not limited to, ethical considerations. On February 9th, a hearing was held on Hobson's motion to withdraw. Hobson addressed a number of issues as for the basis for withdrawing, including disagreements on legal strategy, on what can and cannot be done, a lack of resources, and defendant's demands make her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. And this is not a surprise. Sarah wants what she wants, and she wants everything to be done the way she thinks it should be done, and she wants everybody's reasoning to line up with hers. And it doesn't matter whether it's irrelevant, whether it's admissible, whether it's just not going to work. It doesn't matter. Nothing matters except for what she thinks. When your lawyer says that is non-viable, that will not work, that is not something we can do, you should probably at least consider that. That lawyer is telling you something that is in your best interest. As to a key substantive defense, Hobson advised that the retained undisclosed expert is not keeping with what defendant has in mind. I think they mean not in keeping. The court advised defendant that the court had received a letter from defendant dated January 19th. The court outlined the overriding claims for withdrawal by Padilla, Bankowitz, and Hobson: adversarial relationships, lack of satisfaction, and inability to meet the defendant's desires. The court is saying to her, Ms. Boone, there's a pattern of behavior here, and it's you. The court found that all of the defendant's relationships with all court-appointed counsel have deteriorated such that defendant and the court-appointed counsel cannot work together. The court advised defendant that although defendant has a right to court-appointed counsel, that right is not unlimited. The court twice advised the defendant that the defendant may not be provided another court-appointed attorney, and that the defendant would have to represent herself if circumstances similar to Hobson's motion to withdraw occur. So she's been warned and warned and warned. And every time she's been given leeway, been given lots of grace, more opportunities. And the court clearly said, and they've got this in bold twice, you can't keep doing this. You might not get another court-appointed attorney. And you're going to have to represent yourself if what's happened before with Hobson, if that happens again, you may well have to represent yourself. Warned and warned and warned. And some, if not most of you, have encountered this where you try to set a boundary with somebody and they just violate that boundary. There are certain people who are just going to do that. And once is a mistake. Once is oh crap, I'm sorry. Somebody who continually just does whatever they want anyway, that's a problem. That's a red flag. I know that there's a lot of self-help stuff around setting boundaries, healthy boundaries and all that. Well, with some people, it doesn't work. Yes, we would all like to give everybody the benefit of the doubt, give everybody an opportunity, extend some grace, perhaps give people a second chance. But there are some people who you can't set boundaries with. And if you are encountering that or having to deal with that repeated violation of boundary set, well, consider that it's maybe not your fault, that it's not about learning to set the boundaries better or buying another self-help book on setting boundaries. Maybe that person is just violating your boundaries because that's who they are. Just something to think about. So Sarah's just going to do whatever she wants. Doesn't matter how much she's been warned. The court further advised defendant about the dangers of self-representation due to defendant's lack of legal training and knowledge. I wouldn't want to defend myself, I tell you. No way. Lawyers don't represent themselves. I mean, unless we're talking about a parking ticket or something. I don't think she wants to represent herself. I think she just wants to beat up on somebody else, get somebody else to do the work, but she wants to direct everything. And she wants to make it so that if anything goes wrong, it's not her fault. And having the court force somebody to represent her, she gets a punching bag that can't run away. That's part of why she's so angry when they withdraw. And she says things like, he crept away. These lawyers crept away. They're cowards, basically. She said something like running away from the battlefield. She does not like for anyone to actually tell her no. And walking away from somebody is a way to say, no, I'm not putting up with your crap. She needs somebody to blame. She needs somebody to be able to hurt. She needs to have power. And how dare you abandon me? That's a sin. That's a reason for revenge. So she's warned about the dangers of self-representation. Defendant never stated that she did not understand that she may not be provided another court-appointed attorney. This judge who is crafting this is anticipating the kind of games that Sarah will play. The court granted Hobson's motion to withdraw and appointed Patricia Cashman, attorney number 8. The court is aware of Cashman's extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of murder, and is widely known to be able and willing to deal with and manage difficult clients. So, Sarah's accusation against the judges in the system that they're throwing darts in the dark. Well, the judge here points out this lawyer is known for her skills and willingness in dealing with people who are difficult. If Cashman couldn't do it, nobody can. But I already thought nobody could anyway. I think it's good that the judge included this information on the record here because that addresses Sarah's complaint of, well, you're just throwing darts in the dark. And as I said in my last video, we're not having episodes of the courtroom dating game in order to pick a lawyer. There's no rule that says you have to love each other. I like that the judge included this particular fact on the record here. The court set a status hearing for April 12, 2024. On April 12, 2024, the status hearing was held. Cashman advised as to the depositions that had been set, the hiring of an expert, and a request for a future status date to address a trial date. Court set a status hearing for June 7th, 2024. On June 7th, the status hearing was held. Cashman addressed her dates of availability for trial. Defendant was present for the hearing and was sworn. Thereafter, defendant advised the court to walking out of at multiple meetings with Cashman, which was confirmed. Cashman, utilizing a pretended judge to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism and providing the court with letters dated June 4th, 2024 and June 7th, 2024. I'm going to go back here to the Cashman, utilizing a pretended judge. My reading of Sarah's letter led me to believe, and I still believe, that it was Sarah who created the pretend judge because Sarah wanted to keep Cashman calm. Cashman advised to her efforts and time spent on the case so far, 20 hours. Cashman addressed disagreements on legal strategy, including defendant attaching importance to issues that may not be legally important. Defendant accused Cashman of lies and half-truths. Well, look at Sarah Boone's letters and you tell me who is lying and telling half-truths. But, of course, it's very difficult for Cashman to be able to defend herself because she's not allowed to just disclose everything that was said between her and the client. On June 11th, 2024, Cashman moved to withdraw. Substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client. Also, irreconcilable differences, including but not limited to ethical considerations, have arisen such that counsel can no longer provide representation. On June 28th, the hearing was held on that motion. Cashman relied on a specific rule as the basis for the withdrawal. At no time has defendant refused to accept services of any of her 7 appointed attorneys. So the judge is putting that in there to make that clear that Boone didn't refuse to accept the services. The next section is the law. Both the United States and the Florida constitutions guarantee an indigent criminal defendant the right to assistance of appointed counsel. So they cite the U.S. Constitution, the Florida Constitution, and some case law. The counsel clause of the Florida Constitution under Article 1, Section 16 recognizes the right to counsel as well as self-representation in all criminal proceedings. So they've got a new category here, forfeiture of right to counsel. A defendant in a criminal case can forfeit a right to court-appointed counsel. A forfeiture is an extreme measure that flows from the defendant's abuse or manipulation of the right to counsel and results in the defendant being required to represent himself even though he has not waived counsel and may still want legal representation. And there is case law here. Forfeiture is a judicial response that adopts the course of the legal proceedings to the defendant's choice to engage in misconduct. I'm going to repeat that. The defendant's choice to engage in misconduct. That undermines the legitimate exercise of the right to counsel. She's abusing this whole process. As set forth above, defendants' recalcitrance to the attorneys who were not conflicted out, Padilla, Bankowitz, Hobson, and Cashman, antagonism, hostility, and attacks on the professionalism of Padilla, notably over a year after the fact, see footnote 9 above, of Bankowitz and of Cashman, and personal attacks on Padilla, Bankowitz, and Cashman. Each of these attorneys were required to withdraw. I'm going to go back up to footnote 9. Where are you? Here we go. So that's this June 29th, 2023 letter and the ad hominem attacks on Padilla, and that those attacks were not raised during either the April 29th hearing or during the May 10th, 2022 hearing on Padilla's motions to withdraw. And I want to pay a little more attention to this QQ paragraph. I know the court can't get away with it, but don't you want to just send Sarah maybe the definition of recalcitrance or the definitions of antagonism, hostility, attacks on professionalism? I think that while the judge is certainly telling the truth and backing it up with evidence, everything that is said is backed up by a legal citation. There's a law, and here's what the law says. Here is precedent, and this is what the precedent says. Here's a rule. This is what the rule says, right? And as for things that aren't specifically about the law, he says, oh, this letter, this page, this paragraph, you can see it for yourself. I'll contrast that with what Boone does. Mean, nasty, snotty, unprofessional, unfair. She doesn't put it together with any evidence. She just slings mud. And here's the difference. These words, antagonism, hostility, right, and attacks are characterizations. But if anyone wants to argue with the judge here, well, he has provided right here in black and white, this is where you find it. And he points out that the attacks on Padilla were a year after the fact, because it's not really about that lawyer or any other. This is about Sarah. This is about her lashing out. This is about her using whatever she needs to use and hurting whoever she needs to hurt to make herself look how she wants to appear and to get something for herself. And I find it amusing that in this order, the judge is using a list of words like Sarah did. Antagonism, hostility, and attacks on the professionalism. Except the judge actually has proof and gives it. It has become apparent to the court that the defendant will not permit herself to be represented by anyone. Additionally, the withdrawal of 8 different attorneys, 7 of which were court appointed, leads to a determination that the defendant had forfeited his rights to counsel. They provide their citations. Under Florida law, the facts at bar amount to a binding forfeiture of the right to counsel. Binding, meaning no takebacks, Sarah. As the court finds, defendant has forfeited the right to court-appointed counsel. Under Florida law, there is no obligation to conduct a Feretta hearing or to otherwise warn a defendant of the dangers of proceeding pro se. The judge is covering all the bases here, making sure there's no wiggle room there. I think that they did warn her, but here, right in the document, the judge is making sure that, hey, even if we didn't say anything, or if somebody wants to argue that we didn't explain it enough, it's still covered. I mean, Sarah torpedoed her own ship, right? She sunk here. Waiver by conduct. Oh, I like that. The court can find a waiver by conduct to the right to counsel. Waiver by conduct requires that a defendant be warned about the consequences of his conduct, including the risks of proceeding pro se. On February 9th, 2024, defendant was twice advised that another court-appointed attorney may not be provided. On May 10th, 2022, defendant was advised about the dangers of self-representation. On February 9th, 2024, defendant was advised about the dangers of self-representation. As of February 9, 2024, the instant case had been continued 16 times. As of June 26, this case has been pending 4 years, 3 months, 5 days. Oh my gosh. Oh, this is hilarious. Okay. When I saw 16 times, I wasn't sure if this is really what the judge was doing, but I'm laughing. But you notice it's continued 16 times, and they have listed again all the times that she was warned. It's already set out throughout the rest of the document. They really didn't have to put it in again, but they did. And 16 times, pending 4 years, 3 months, 5 days. Should I do it? Okay. Should we call the count? I think we have to call the count. And notice it's underlined and bolded here. Don't say judges don't have a sense of humor. Actions speak louder than words. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing defendant, her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage defendant to persist in efforts to present the resolution of the case on its merits, the concept of which was first brought to the defendant's attention on May 10th, 2022, so 2 years ago. Defendant complains that Bankowitz and Hobson, 2 court-appointed attorneys, failed to meet and communicate, and when defendant is provided court-appointed counsel who will meet and communicate, Cashman, the ways and means of meeting and communicating are unacceptable to the defendant. Yep. And I just want to look at this footnote here. Even taking into account the impact of COVID-19 pandemic and the suspension of criminal trials, this case has been pending 1 year, 9 months, 9 days. Sarah thought she could do whatever the crap she wanted and keep doing it, and thought she had won over on everybody. And she also took pleasure in sticking it to other people whenever she could, in whatever ways that she could. At the scene of the crime, she told the first police officer there that she left Mr. Torres in the suitcase and thought, I just wanted to make him squirm. I wanted to make him squirm. She thinks she can just do what she wants, even to the point where it causes another human being's death. And it doesn't matter what the consequences are to anyone else, as long as she doesn't have to have consequences. Well, now somebody's called her on it. She has been given opportunity and more opportunities. And this judge is not playing, and good for him. And the judge has all the receipts. And the judge rightly points out, even when Sarah is given what she claims she wants, well, then there's some other reason why she's not happy about it. Listen, people in the justice system have seen this crap before, right? You give the benefit of the doubt as far as you can. But there comes a point where if you allow anybody to exploit and manipulate and abuse the system that is for everybody. As flawed as any system is, the idea is that it is for everybody. She's not the center of the universe. She's not the center of the United States. And if anyone is allowed to exploit that, there's a point at which continuing to permit that abuse of the system and that undermining can bring the administration of justice into disrepute. So good for him. Finally, somebody's telling her, guess what, lady? Whether you like it or not, no matter how much you cry about it and wail, poor me, you're responsible for your actions. And the answer is no, and you're going to have to accept that, whether you like it or not. Under Florida law, the facts at bar amount to a binding waiver of the right to counsel. Means you're toast, honey. Here are the judgments and orders. Cashman's motion to withdraw is granted. As a condition of Cashman's withdrawal, Cashman shall provide the court an order for costs to obtain transcripts of depositions for the two witnesses Cashman deposed. Upon completion of the transcription of the depositions, the deposition transcripts shall be sent directly to defendant Sarah Boone by Cashman at the Orange County Jail. Thereafter, Cashman shall file a notice with the court reflecting that the depositions transcripts were provided to defendant Sarah Boone, and such notice shall include the date sent and the address of the defendant. This judge is going to make sure that Sarah can't come back and say, oh, they lost it, I never got it, she's not sending it, blah, 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 right? The court is going to protect everybody here. Cashman has to provide the information to Sarah and then file the notice with the court. You see, this judge knows he needs the receipts for everything all along the way. So Sarah's not going to be able to come back and try and play games with this or make vague allegations about this. Defendant Sarah Boone has forfeited her right to court-appointed counsel. Bye-bye, Fluffy. Alternatively, defendant Sarah Boone has waived by her conduct her right to court-appointed counsel. This is different from right to counsel, period. She still has a right to counsel. She just doesn't have a right to yet another lawyer paid for by the taxpayers. The trial management conference shall remain specifically set for Tuesday, September 24th, 2024 at 1:30 p.m., meaning we're not changing it. This case shall remain specifically set for trial for the 2-week trial period beginning Monday, October 7th, 2024, and will not be continued for any reason except by extraordinarily good cause. And such extraordinarily good cause shall not include retention of counsel by the defendant. So, unless there's a flippin' hurricane or something, unless it's something extraordinary, she is going to trial on October 7th. And even if she runs out and gets another lawyer herself, if her fans pay for a lawyer to come and represent her, that lawyer has from the time that he or she is retained until October 7th to be fully prepped, get experts, whatever it is that they're going to do, if she in fact ends up finding a way to hire somebody privately, and they can't then come forward, as has been done in the past, to say, hey, I'm a new lawyer on the case. I really need time to prepare. Otherwise, this will go on forever. And the judge sees that. And the state called it right in the beginning. So we're having a trial. I guess I better get streaming software and figure out how to do that so I can stream the trial live and talk to you guys. Any and all pretrial motions in this case must be filed no later than the close of business on Monday, July 22nd. Ooh, oh boy. There's a very clear deadline, so there's not going to be any messing around that way either with last minute motions. Done and ordered 28th of June, 2024. And here's the certificate of service. And Sarah Boone was handed this order. She can't say she didn't get it. She doesn't know. Wow. She's gonna be mad. We're gonna see more letters about how unfair it is. We're gonna see letters about how there's a missing discovery. You wait. It's gonna be unfair. Finally, there's gonna be a trial. And you know what has not been mentioned in her letters, her complaining, in all of these court hearings? There's one very important issue that has not been addressed. And that is, what about the victim? What about his parents? They're getting older. His kids, his brothers, his friends. Do you think maybe they want to know what happened? Do you think that maybe they want this circus to end? Do you think maybe they want somebody, the evidence, to give Mr. Torres a voice one more time to tell what happened to him? Do you think maybe living like this without this person who they loved and without justice and with this woman getting all this attention, do you think maybe that's difficult for them? Kind of hard to turn the page. I hate saying the word closure because it's not really closure, right? But how do you move on with this? Mr. Torres deserves to have his case heard, his story told in this. So good for the judge. He's not playing. That's all I've got for you for now. Trust your gut. I'll see you in the comments.